Alright guys, what you're about to see is courtroom tension at its peak. A defendant walks in thinking he knows the drill, but the judge, he's got a different plan. No smiles, no mercy, just stone cold law. Cameras are rolling. Witnessed what happens when the justice system stops playing around. Buckle in.
Good morning, sir. Are you Devon Keith Berley? And Mr. Berley has two cases that he is currently on probation for, and motions to revoke probations have been filed in each of those. Cause number 18-28800 on probation for violation of a protective order, and also in 18-29063 on probation for violation of a protective order. Those are both deferred probations. Mr. Burbank has filed requests in both of those cases asking that I set bonds. Sometimes I do that without a hearing, but due to the nature of the underlying offenses as well as the new alleged offense, I wanted to come and hear from probation and the state as to what your position is with regard to any bond that I would set. Ms. Malfino?
Yes, ma'am. Judge, obviously I will defer to whatever Ms. Johnson thinks is appropriate. I do want to let the court know I did reach out to the complainant in the underlying offense. I've actually maintained contact with her just on a friendly basis since the original offense that I handled back in 2019, just to be able to assure the court that those issues do not involve that complainant, the issues that he's having now. There is no issue with the Hartley family, which I was glad to hear. Obviously, my concern is that there's been another assaultive offense.
The judge calls out Lester Ballard, a name he's seen before. This time, it's for aggravated assault with a deadly weapon, stemming from a July 2024 incident. But Lester's no stranger to this courtroom. The real shocker, he's already a convicted felon, and this charge just cranked up the heat. The judge lays it down. This is serious business now. No room for slip-ups. You can feel the courtroom tighten as the judge sets the tone.
There's also been an allegation of a possession of a controlled substance, so two new offenses while on this bond, in addition to multiple violations, in addition to everything that Ms. Johnson has already made available to Mr. Berley. So I know that he's entitled to a bond as he is on deferred.
Maybe he is without certain findings, so that's why we're here. So just also for the record, Mr. Berley, and I know you know this, but I'm going to go through just so that we're all clear what the allegations are in that motion, and just that they're allegations, and obviously they haven't been proven true. But it looks like you have an allegation that you committed an offense of assault April 21st of 2025, that you tested positive in a urine sample for opiates, that you did not provide verification of attending the JCDI program. Looks like there was another urine sample that tested positive for alcohol in April of this year.
With Lester standing silently, the judge flips through pages. He's not just reading, he's building a case of repeat recklessness. The prior conviction isn't just a mention, it's the foundation of this charge. The state sees him as a repeat threat, probation. Unlikely. The courtroom knows what that means. The judge's voice stays calm, but sharp. He's not playing games. Lester's past just slammed the door on his chances. This is going to trial. No more warnings.
Then it also alleges that you committed a new offense of possession of a controlled substance, May of this year, that you possessed crack cocaine, which is the same date as that offense, and that you were at a location other than your residence at approximately 3:19 a.m. on May 29th, the date of that offense of this year. So what do you have the status? I know the lab, we've had some issues with lab results. Is there any idea on that, Ms. Malfino?
I do not know, Judge. I would venture to guess that with it only being several weeks ago, we probably do not have anything. I'm happy to reach out to the agency and ask if they can expedite that through the lab and be prepared for a hearing whenever the book is.
And Ms. Johnson, thank you for being here. And so what is your thought, I guess, with regard to setting a bond, and if I did set a bond?
Now the prosecution speaks. They bring the heat, reminding the court that Lester's actions have consequences. A deadly weapon, a repeat conviction, and public safety concerns. That's their angle, but defense doesn't stay quiet. They argue, Lester's side, pushing for leniency. But with a prior felony hanging overhead, it's like playing chess against a wall. Every move is blocked. The judge listens, but his face Stone, the weight of the law is pressing down on this man hard.
What specific conditions do you think would be
So I
helpful?
received his case. I became his officer in February of last year.
Okay.
And since then, I have put him in ISF cognitive. I have put him in JCDI. Prior, he's been an MRT. He tells us that he understands that he has a drug problem, but then still continues to go do what he's doing. We've tried to help him as much as we can. And I went and visited him, I believe last week or 2 weeks ago, and he told me the reason he would need a bond was so he could go work out of the county. And I don't think that's a smart decision. If you put him on bond, I would say a drug patch would be smart. A GPS would be smart, but ultimately, Your Honor, it's up to you, but I don't think a bond is a smart decision.
Yeah, I don't
The judge now shifts focus to bond discussion. Defense asks for a chance house arrest, maybe monitoring, but the judge raises a brow. Given Lester's history, why should he believe anything's changed? This isn't just a pattern. The judge emphasizes public safety. He's thinking of everyone outside that courtroom, and right now, Lester looks like a walking risk. The bond discussion doesn't go well. You can feel the defendant's heart sinking.
You may. Go
Can I
ahead.
ask a question? When did you place it on JCDI? Do you have a date when this time? When was you actually placed it? Was it 2019 when you placed on probation?
For probation?
Yes.
2019, May 13th.
When did you place him on JCDI? Was it just recently?
Yes, sir. It was in the last.
February of 2025.
Okay, so what changed between 2019 and February 25 to say now you need JCDI?
His drug intake went up. We've tested on multiple occasions. He's tested positive for cocaine on multiple occasions, and we believe outpatient would be the best for him. He had spoken to me briefly as well that he had some issues he wanted to talk through. He had some family issues he wanted to talk through. So we got him being in front of a counselor, him getting the drug treatment is what he needed. He agreed with us that's what he needed. So he believes that outpatient program is the best option for him.
Did he go to JCDI?
He did. He did test positive on multiple occasions. He drank at one point and he admitted that to us.
So when did he stop going to JCDI, or was he still going at the time of this offense?
He was still going at the time of the offense, but since he picked up a new offense, they had to drop him from that program.
So it was the new offense that dropped him, it wasn't him not going?
As well as the drug use.
And was there another program too that you said?
He had done ISF, cognitive track.
And what is that?
It is the interesting facility that we send people to, about 90 days long, and he went the cognitive track, so the thinking track.
And roughly when was that?
March of 2024.
Thank you.
All right, anything else, Mr. Burbank?
Mr. Berley, you've heard what the probation officer said. Did you talk to the probation officer?
Yes, sir.
Speak up so we can hear you.
Yes, sir.
If the court was to allow bond, what is your plan in reference to what you would do when you got out?
As far as my plan, I mentioned to my probation officer, and I believe I mentioned also to you that I would like to get into an outpatient program at that rate choice if possible, which will allow me to, I just told you that I couldn't work out of the county.
With each word, the judge builds a wall. Because of the deadly weapon involved and the felony history, he pauses, then drops the hammer. You're staying in? It's not personal, it's policy. But for Lester, it hits like a brick. This isn't just about jail. It's about loss of control. The defense looks stunned. The room, dead silent. And in that moment, the gavel hasn't dropped, but the sentence feels halfway delivered already.
Is that approximately 3 o'clock in the morning, 3:20 in the morning, you were sitting in a running vehicle in an empty parking lot in an area known for prostitution and drug use. You roll down the window to speak to officers. White smoke comes out of the vehicle. You get out. You got crack pipe, allegedly. 4 pieces of crack were found on you, allegedly. my fear is that I don't know whose car you were in, but obviously it's scary to think that you're out possibly driving in the middle of the night, either finding drugs, using drugs in the wrong area after this is your 5th administrative hearing. So you've already been given 4 opportunities with probation without having come in front of me on an MTRP. They've gone so far above by letting you work out things administratively with ISF, with JCDI, and I approved those things, but they did those things without saying, let's revoke his probation, let's work with them, let's work with them, let's work with them. And then here we are, while you're in supposedly the JCDI program, which is exactly what you say today you're asking for, outpatient treatment program. Based on the underlying offenses and the nature of those offenses, based on the nature of the 2 pending charges against you, I am going to find that setting a bond is not in the best interest in these cases of our community. I am going to leave it at no bond in these cases. We can handle this a couple ways. We can go through the motion. We can get pleas of true or not true. We can set it for a hearing for sentencing. If, depending on what the plea is on the, excuse me, the new charge of possession, we can get with the lab and I can ask them to get that done before that hearing. We can take care of that at that hearing.
Right, I mean, I'm advising not to enter a plea in reference to the new offenses until we know exactly what it is. And
That's
so
fine.
there may be a question.
I think we can get that taken care of if I see y'all back at sentencing.
Maybe excuse to that.
Yes, sir. Thank you.
Finally, the judge addresses scheduling. Trial dates. Next hearings routine for the court, but monumental for Lester. No bond, a second-degree felony, and a prior strike already in his record. He's walking out the same door he came in, but now it leads to months behind bars. As the camera fades, the judge leaves no doubt. This courtroom doesn't run on hope. It runs on facts, records, and consequences. Justice served. No